Most group long-term disability insurance policies are governed by a federal law called ERISA, or the Employee Retirement Income Security Act of 1974. ERISA can limit how you can appeal or file a lawsuit when your benefits are denied. But not every group policy falls under ERISA. Hi, I'm Leah Small. I'm managing attorney here at Chisholm & Kilpatrick, a leading public interest law firm based in Providence, Rhode Island. Joining me today is Emma Peterson, a partner here at CCK Law. Today, we'll be discussing ERISA and which group policies are exempt from it. Before we begin, be sure to like this video and subscribe to our channel for more LTD content.
Thanks, Leah. Before we get into explaining which group LTD policies are exempt from ERISA, can you first give us a little background on what ERISA is?
Absolutely. So ERISA is a federal law, and it sets rules for employee benefit plans, including long-term disability insurance. This law applies to most employer-provided group policies, but it typically does not apply to individual insurance policies. Under ERISA, you typically don't have the right to a jury trial or things like punitive damages if you have to fight for your benefits in court. Additionally, the court may also give deference to the insurance company's denial in court. But it's important to remember as well, before you even get to court, that under ERISA, the appeal process is also highly structured.
Okay, so which group long-term disability policies are typically exempt from that structured ERISA system?
So there are primarily two types of group plans that are exempt. First is government plans, or policies that are sponsored by local, state, or federal governments. This can include things like policies from public school systems, state universities, municipal agencies, and others. The second big exemption is church plans. Plans offered by religious institutions or businesses maintained by religious organizations can be exempt from ERISA. This can include certain hospitals, schools, or nonprofits that are run by churches or other religious institutions. However, church plans can choose to opt into ERISA if they elect to do so. Now, there is also a third category that can be exempt from ERISA, and that's group plans that are not actually established or maintained by an employer. May end up being considered exempt from ERISA in certain situations.
Okay, why does it matter if an individual's group policy is governed by ERISA or not?
So claimants may actually have stronger legal rights under state law if ERISA does not apply. For example, it may give them access to a jury trial if they have to litigate a denial of benefits, and they may have the potential to get bad faith damages, again, if they're in litigation of a denial. And there are just in general broader discovery and evidence options in litigation when ERISA does not govern your claim. Additionally, even before you get to litigation, the appeal process may be more flexible in non-ERISA claims. And in general, the insurance company may face higher risk for mishandling claims.
Okay. How can a person tell if their LTD policy is exempt from ERISA?
So a good starting point is, of course, examining who the plan sponsor is and looking at, do they seem to fall under the government plan or the church plan exemptions? You can also investigate whether the plan has filed a Form 5500, as that may give an indication that it's ERISA governed. But, as always, if you have questions, you can consult with an ERISA attorney to help clarify.
Thanks, Leah. ERISA doesn't govern every group LTD policy, and knowing whether your plan is exempt can make a major difference in how you approach your claim or appeal. If you're not sure how your policy is classified, or if you've received a denial of your LTD claim, CCK Law may be able to help. You can reach out to us anytime to request a free evaluation with a member of our team. Remember to like this video and subscribe to our channel for more LTD content. Take care.